morning.
Morning, Your Honors. May it please the court, I represent the appellant Daniel Sturmer as creditor trustee for ATIP Inc. My name is Keith Meehan. I'd like to reserve 5 minutes for rebuttal.
Very well.
This is an appeal by Sturmer, the creditor trustee, following a summary judgment granted in the defendant's favor due to lack of standing for what the court categorized as an improper assignment. The lower court found that the assignment was improper, notwithstanding a confirmation order entered in the bankruptcy case, as well as other orders in that bankruptcy case that expressly authorized the transfer of these malpractice claims to my client and the creditor trust.
I thought there was a carve out of various claims.
So in the creditor trust, all the claims of ATIP were assigned to the creditor trust, and then the creditor trustee, my client Sturmer, was the trustee of that trust. It also specifically authorized and laid out all the malpractice claims that were being directly transferred to the creditor trust. This confirmation order, along with all these multiple orders, all the defendants were a party to.
Counsel, would you agree with Supreme Court statement in the Stern case from 2007 that generally assignment of a legal malpractice case is prohibited under foreign law?
I think generally that is the case, but I think you also have to look at the Cohen-Leibowitz versus Kaplan case as well, which says that there's no longer a blanket prohibition on the assignment.
But that's not what the court said in Stern. Stern kind of reined in Kaplan and limited it to its facts and admonished for the future that we aren't to go on a case-by-case analysis of what policy effect such an assignment may or may not have. And in this instance, didn't the parties contemplate this exact scenario and provide a different vehicle by which the claim could be made to the CLO?
So, I think not really. I think that provision is more of a catch-all provision. If you look at how the parties actually participated in the bankruptcy case, it was clear that all these claims were going to be assigned to Sturmer. After the plan was confirmed and heard by the court, after that fact, it was Sturmer that took all the steps to then prosecute malpractice claims, including hiring counsel like our firm. All of those orders were entered in the bankruptcy court even after that, expressly authorizing Sturmer as the one who was prosecuting his claims, not the debtor's consolidated CLO. And the debtor's consolidated CLO was not active at all in this and never took any action on malpractice claims because everyone knew that these claims were being pursued by Sturmer. And I do think that in Stern, it's also important that the court talks about how it's not receding from its prior rulings in Kaplan. And Kaplan was an ABC case and state court bankruptcy case. And in Kaplan, it talks about how
I have to take issue with your last statement about what the Supreme Court was holding in Stern, because I'm reading from the opinion on page 10. Kaplan was the first and only case in which this court permitted a limited exception to the general prohibition on legal malpractice assignment. And our holding was confined to the specific facts and circumstances of that case. In other words, it seems to me that the Supreme Court in Stern is reiterating, look, these sort of claims are not assignable, except under very limited exceptional circumstances, so limited that Kaplan was almost a standalone, the way I'm reading it.
So, and I think in Stern, or actually, well, no court in Florida has specifically addressed this exact issue. And then there's multiple cases that talk about how you've got to analyze these sorts of assignments within the context of a bankruptcy case. And
yeah, but let's look at that. Okay, so we have the law of Stearns, and I think even some bankruptcy courts has recognized that legal malpractice claims are not assignable. So you look at the plan in this instance, and the plan specifically provides for a provision that in the event there are, pursuant to non-bankruptcy law, then there's the CLO that steps in. So this was contemplated, and I don't see how we can, and certainly the trial court didn't ignore it. I don't see how we can ignore that just simply because the parties thought they were acting properly and wanted it, and the trustee here wanted to pursue those claims. We can't. That's the plan. That's what was confirmed by the bankruptcy judge.
so, and I think in Stern also, it also goes through all the policy considerations of these malpractice claims, and there's been no court that specifically addressed the issue of whether or not in a bankruptcy proceeding can a claim be transferred from either a trustee or a consolidated debtor to a post-confirmation trust entity where the trustee is solely acting in the exact same capacity and in the exact same way as a bankruptcy trustee. In Kaplan, it talks about.
No. The bankruptcy trustee is not acting in the same capacity. Correct? The bankruptcy trustee it owns property of the estate.
Correct.
Your client is pursuing claims solely on behalf of a creditor group.
So the creditor group was assigned all of the duties and powers of a trustee, and everything was transferred to it. This happens all the time in bankruptcy proceedings.
Except to the extent, as Judge Smith says, as otherwise prohibited by the law.
And there's no court that specifically addressed this issue, and there's a whole litany of case law in other states that have the same general prohibition on malpractice cases, that when you go through the analysis of whether or not this transfer is prohibited by law, all the courts that have analyzed this exact issue have said that these claims are allowed by law. And the first case there is a Jennings.
But in any of those cases, do they have the specific provision like we have in this case, where there's basically a default for claims that that could not be assignable?
I don't believe there was this provision in this case, but I'm not 100% certain, to be honest.
So I don't see how this case, where we have this plan that was confirmed, and on these actions, how this can be assignable here for the trustee the creditor trustee to pursue here.
So you also have orders after the confirmation order that were entered by the bankruptcy court that are authorizing Sturmer to hire and prosecute these claims. That's what was contemplated in the bankruptcy court. It's not.
And are those cases binding on us?
So they're not binding per se, but they are instructive because they are the only cases that have ruled on this exact issue.
I don't think any of the cases you cited, correct me if I'm wrong, were decided after Stern's very firm reaffirmance of the general rule that legal malpractice cases are not assignable. I know Jennings was predated Stern.
So Jennings was after Kaplan. It was before Stern.
Right.
But there are, I believe I have a 2010 case.
Kaplan was very unique. It reminded me of an accounting case that I looked at way back, where the only reason that the cause of the claim was allowed was because there was third-party reliance on the advice, and the lawyer knew there was going to be third-party reliance. I believe that's the same workaround on the privity problem with a CPA issuing financials.
And so that is the case, but in Kaplan, it was an ABC proceeding, which is kind of like a state court bankruptcy proceeding, and it specifically stated in that ruling that upon the filing of a bankruptcy, all malpractice claims are assigned to a bankruptcy trustee. So the Florida Supreme Court is already confirming that in a bankruptcy, all of these claims are automatically assigned to the bankruptcy trustee. And then you have the Jennings case and the Parrott case, Henry Porter McLeod, Antioch and Jewell. At least one of those I do know is a 2010 case, which is after Stern, but they're all cases that specifically analyze in states like Colorado and Texas. So Kaplan cites to or references all the states that have a general prohibition on ordinary assignments, and cites to Colorado, and it also cites to Texas. I have cases.
You're asking us to make an exception because it's a bankruptcy case?
Yes, because all the cases
So
that
we would be extending the law in that area insofar as opening it up to a claim that isn't presently authorized in Florida law. This is something new.
It's also not specifically denied either, and I think these are this issue has never been applied, and because it's such a limited issue dealing with bankruptcy procedure, the efficient administration of bankruptcy cases, 11 USC 1123 specifically calls for and authorizes transfers from a bankruptcy trustee to a trustee whose sole purpose is to act on behalf of the creditors, just like a trustee in a bankruptcy case, to pursue these claims. This is what happens in a bankruptcy case, and is specifically authorized by bankruptcy law in all the bankruptcy cases and all the cases that have analyzed this exact issue.
Is the authorization of the assignment by the bankruptcy judge to the creditor trustee the same as an appointment by the court?
The court appointed Daniel Sturmer as a trustee to prosecute these claims. So
your opponent makes a distinction between an appointment and an assignment. I think that's the question that's before you.
So the claims.
But in this case, the assignment to Sturmer was, he readily agreed that he was not standing in the shoes of ATEF and was not prosecuting a claim on behalf of ATEF. He went out of his way to sort of separate and distance himself from ATEF.
Sure, and just like a bankruptcy trustee is prosecuting claims on behalf of the bankruptcy estate, that's exactly what Daniel Sturmer is doing here. The creditors are the beneficiaries of any claim in a bankruptcy case. When you have a bankruptcy case, all the property of the estate is to be liquidated for the benefit of the creditors. Daniel Sturmer is representing all of the creditors in his trustee capacity, and he was specifically appointed by the bankruptcy court to pursue these claims by virtue of the assignment. So you have the assignment, and then you also have the appointment the appointment of Sturmer as the individual who is then to prosecute all these claims on behalf of the bankruptcy trustee or the consolidated debtor in this case. It really depends upon kind of.
And is that, are you relying on the plan and the trustee agreement?
Yes, Your Honor.
Okay,
So
is there there's no separate order appointing him?
I don't know that specific detail. That's probably better suited for my bankruptcy colleagues like Thomasana, but I believe through those orders, it's confirming everything that's specifically listed in the plan, which is that Daniel Sturmer, he's the trustee, he's appointed to represent the creditor trust and to prosecute these claims on behalf of the estate. And so I think, again, all the cases that have analyzed this exact issue, which is the Jennings case in the District of Florida, specifically said that these claims are property of the estate. 11 U.S.C. 1123 specifically calls for these plans to provide for someone else to retain and enforce these claims. That's exactly what happened here. And that court found that there's a limited modification when the entity acquiring the claim is not acting in its own personal interest, but is instead representing the creditors of the estate. That's what we have here. Sturmer is not acting on his own capacity or the creditors. He's for the bankruptcy estate, which are the creditors. And the entity pursuing the claim was expressly authorized by the bankruptcy court. That's exactly what we have here in our case. Sturmer was expressly authorized to prosecute these claims on behalf of the
One other thing I just happen to remember was that at some point, I believe Sturmer went back into bankruptcy court to try to get some sort of an injunction.
Yes, Your Honor. So
And the bankruptcy court said, wait a minute, this is a state court issue. The state court has to make a determination of standing. This is not mine.
And the court did absolutely do that, but I think it was important that all the cases that the court highlighted and went through and explained were all cases where the courts found that the litigation trustee of the post-operation trust had standing to pursue these claims. And the court referenced the Jennings case, it referenced the Parrott case, and it also referenced the Henry Porter McLeod case. All these cases specifically analyzed the issue in states where you have a general prohibition on ordinary assignments. Can you transfer a claim to a liquidation trust as part of a post-confirmation plan? That's exactly what we have here. All the cases that analyze that very, very narrow, limited type issue have all ruled the same way, which is that these claims are absolutely allowed. And that's what I believe the bankruptcy court was highlighting. At the least, the cases that she went through were all cases where there was standing by the liquidation trust to pursue these claims. A couple of things too. In the Parrott case, it even says that the general rule prohibiting assignments must be examined in the context of bankruptcy law, and that's what is so important. It's a very, very, very limited issue. And also in the Parrott case, it talks about how this transfer or this assignment does not change the beneficial owner of these malpractice claims. It's still the bankruptcy estate itself, which is the creditors. In the Henry Porter McLeod case, again, it was a post-confirmation trust transfer, and it talks about how being able to do this promotes the efficient administration of the bankruptcy estate. It does not encourage unjustified lawsuits, and the assignment was just for the purpose of pursuing these claims pursuant to a post-confirmation plan. The Antioch case that I cited, Your Honors, again, it talks about how this is consistent with fundamental bankruptcy law, and that a litigation trustee stands in the shoes of the debtor. Just like we have here, Sturmer was authorized to prosecute these claims, was vested with all the powers of bankruptcy trustee to prosecute these claims on behalf of the estate. And then we also have the Jewell case, which is from Texas, which is another state that was cited in Kaplan as having a general prohibition on ordinary assignments. This case went through the whole analysis and found that the trustee succeeded the debtor in possession as the representative of the bankruptcy estate to prosecute these claims. That's all it is, just a different person representing the estate to prosecute these claims all the way through.
Mr.
And
Means, excuse me, you're up to 15 minutes in your argument, so
I'll say
proceed as you
something.
wish.
I'll wait for a vote.
Thank you. Mr. Webb?
Yes, good morning again, Your Honors, and may it please the court. Josh Webb here along with my co-counsel Dennis Wagner from Philip Henderson on behalf of the appellees and the defendants below, Carlton Fields, Nathaniel Dollar, Christopher Smart, William Giltinan, and Marty Solomon. If I could, I'd like to first respond to some of the points from appellant's counsel this morning and raised by the court. Then I'd like to highlight key parts of the record, the factual record, that are really kind of ignored in the appellant's briefs and arguments. And then finally clarify and frame the issues as they fit within the authority from the Florida Supreme Court, which we have here. No need to go to other jurisdictions. We have the authority on point from the Florida Supreme Court, and explain why the lower court was correct to grant summary judgment. So some of those points from appellant's counsel and the court already this morning, I think there was reference made to other orders in the bankruptcy case that pertains to this case. I don't believe that any of those other orders are in the record. In fact, I believe the order that the court was referring to was the order confirming the plan, which included, importantly in this case, the creditor trust agreement, which has, most importantly, the operative provision that we have relied on in our arguments supporting summary judgment and opposing the arguments here on appeal, and that really appellant tries to ignore and sort of cast out of the record. So that is the operative order, if there is any, from the bankruptcy court. There was a question about whether any of the other cases had a similar provision. What the court called a carve-out provision this morning, we referred to in the lower court and here as the contingency provision. None of those cases had a similar provision to this, and that is why that provision is so important in this case. And it's not a catch-all generic provision as was referred to by appellant today. Finally, the point that was made about no case in Florida, or at least from the Florida Supreme Court, considering bankruptcy aspects. Here, this is not a case where that needs to be done, because again, you have the parties in the underlying bankruptcy with a plan and the creditor trust agreement, and I'll highlight, illustrate some of those provisions in just a second, creating that carve out and saying where an assignment cannot be made, where it's prohibited by applicable law, in this case, Florida law, then here is what needs to happen. The creditor trustee, the appellant here, did not abide by that. Just because things went on, that means just that. The appellant did not abide by what the plan and creditor trust agreement provided for in the event that there was an assignment made against a prohibition provided under state law. So the assignment, I think, is clear to everyone that that is the manner in which the appellant proceeded with this case. It was highlighted throughout the summary judgment record by appellant himself in the lower court. It was highlighted in appellant's initial brief in this court, and even further emphasized in appellant's reply brief. As we've discussed at length already, that was part of the bankruptcy plan and the creditor trust agreement. And again, importantly, and in the record is the provision of the creditor trust agreement that says it controls over the plan to the extent that there is any discrepancy. Although here it is consistent in what it provided for, in particular, that operative provision, the carve out, as the court referred to it, the contingency provision, as we call it, which says that the assets, certain assets cannot be transferred without violating non-bankruptcy law. Those are to be pursued by the debtor's chief liquidating officer rather than the creditor trustee, who's the appellant here. And so that gets us to kind of a third point, perhaps the most important, and that is the debtor entity here for ATIF exists entirely separately from the creditor's trust. That's explained in the bankruptcy plan. It's explained in the creditor trust agreement, and I'll highlight some of those provisions. The debtor entity had a chief liquidating officer who was the representative of the debtor. He stood in the shoes, to the extent there was an individual standing in the shoes of the entity, it was the chief liquidating officer. Appellant here is the creditor trustee, and importantly, a fiduciary only for the separate creditor's trust. In the creditor trust agreement, page 691 of the record, it states that the creditor trust shall have a separate existence from the consolidated debtor. In the plan, at page 889 of the record, the creditor trustee is explained to be bound by a strict fiduciary duty and responsibility to the creditor trust, not to the debtor entity, ATIF. Going on at page 895 of the record, it explains this is the name of the provision in the plan, the continued corporate existence of the debtor entity. The next provision explains the role of the chief liquidating officer. The debtor CLO shall remain in place and be responsible for overseeing and advancing efforts regarding consolidated debtor with respect to prosecuting, liquidating, and or otherwise monetizing the retained assets. The retained assets are defined in the plan. That definition is consistent with the operative provision in the creditor trust agreement because it explains retained assets as those assets and causes of action that are not transferred to the creditor trust, including without limitation, causes of action to the extent they are not transferable pursuant to applicable law. Those provisions all exist in the record in this case. The fact that appellant operated outside of those provisions, against those provisions, that does not change the outcome here. The lower court summary judgment based on appellant's lack of standing should be affirmed because this action was based on an assignment of legal malpractice claims generally prohibited by Florida law. Appellant has no other privity. Appellant does not stand in the shoes of ATIF and does not have privity with the appellees here, Carlton Fields firm and its lawyers who perform legal services only on behalf of ATIF years before the bankruptcy occurred. And there is no res judicata effect. The record in this case, to the extent that we are talking about the policy concerns that have been addressed as justifications by the Florida Supreme Court, this case exemplifies through its record what is wrong with the assignment of alleged legal malpractice claims. Here we have a stranger, an after-the-fact trustee of a creditor's trust, not the actual client, not even the still existing representative of the debtor, the former client debtor entity, who's bringing an unjustified lawsuit, embarrassing an attorney-client relationship based on revisionist history. The assignment here, as the court has already recognized, falls within the rule announced, really reaffirmed in Stern by the Florida Supreme Court, that most assignments of legal malpractice claims are prohibited by Florida law. Kaplan was, in fact, the lone exception to that rule. And in the questions earlier, the court, I don't think that we heard from the appellant what really was the focus of the court's decision in Kaplan, but I think the court asked some questions about it. And that was, in that case, Kaplan, the work that was performed by the lawyers was on a private placement memorandum. And what the Florida Supreme Court really emphasized was that that work was done for the benefit of third parties, not necessarily the client. And in fact, the Florida Supreme Court in Kaplan did make the analogy or comparison back to its earlier decision in the KPMG case, which was an accounting claims case based on an independent audit. And the court found that because an independent audit is really being done and provided for the benefit of others besides the company, that this was more akin to that. That was the sole rationale for the exception that the Florida Supreme Court allowed in Kaplan. That is not the case here, and I'll come to that comparison in just a minute. The appellant here does not otherwise have standing. He's not in privity with the appellees. Nothing about the Florida Supreme Court's decision in the Arch insurance case changed that. which we included a discussion about that in our answer brief. And in addition, the appellant really can't even make that argument because it was not raised below or in the initial brief in this case. I think that on the assignment privity issue, it helps to talk about what this case is not to help underscore what it really is. This case is not the Kaplan case, which was specifically confined to the circumstances there. It is not like the Arch case. As I described, the Kaplan case, the Florida Supreme Court was talking about work done for a third party in comparison to an independent audit. What the statement in Kaplan, I think, was most important, says, nevertheless, we stress that the vast majority of legal malpractice claims remain unassignable because in most cases, the lawyer's duty is to the client. That's a particularly important statement as it pertains to this case, because the allegations that were made in this case were all about the appellee's duties to the client. The allegations were about breaches of the duty of loyalty, taking on a conflicted representation, albeit in the face of informed consent provided by the client to the representation itself. And Stern, the decision in Stern by the Florida Supreme Court reaffirmed that rule. And it said, broadly speaking, most of these assignments cannot stand. So that exception for Kaplan is where there's something perhaps done for the benefit of others. That is not this case. The Arch case that I'll touch on just very briefly really doesn't have anything to do with this. The Arch case, if anything, underscores the problem with the appellant's position here. Arch was all about a pre-existing contractual subrogation provision where you had the insurer who was seeking standing or arguing about standing to pursue a claim against the law firm, was there from stage one, was not a stranger to the relationship. Much different than the case that we have here, where you have this after-the-fact trustee only coming into the fold many years after the fact, not a part of the original attorney-client relationship. So again, it's just a very different situation because this case is really about that. It's a stranger taking an assignment of a legal malpractice claim when the former client's representative still exists. To come back to that operative carve-out provision in the plan and creditor trust agreement, the debtor entity ATIF still exists with a chief liquidating officer with a provision that specifically explains when you can't assign a claim, which Florida law prohibits in this instance, the chief liquidating officer was the one, if anyone, to pursue that claim. That didn't happen here. The lower court found that, heard about that, relied on that, and that is what drives the outcome in this case. Summary judgment was correct for that reason. Unless the court has any questions for me, I think that really addresses the key issues that are here. We've briefed the other arguments that appellant has made, and that's all I really have.
Thank you, Mr. Webb. Mr. Meehan?
In this case, it was Sturmer who was charged with the task of taking control of, supervising, managing, and liquidating ATIF. And that's what happened in the bankruptcy case. These claims were assigned to him in order to effectuate that purpose. After those orders took place, there were additional actions and orders that took place in the bankruptcy court, not cited to the record 1278 to 1280, where additional steps were being taken and approved by the bankruptcy court to have Sturmer, not the consolidated debtor CLO, to actually be the ones prosecuting these claims. In fact, the defendants in this case signed a tolling agreement with Sturmer in his capacity as the party prosecuting malpractice claims. So even at that point in time, as the party authorized to prosecute these malpractice claims. As I went through the cases before, none of the public policy concerns are that are raised in a typical assignment of a practice case are present here. All the cases on point that I cited to that analyze the public policy portion all say there are no public policy concerns at all. There's no worry about claims being sold to the highest bidder. There's no worry about a market or anything like that. None of those concerns are here. And Sturmer has all the competences of ATIP in the underlying case, so there's no concern about client competences or things like that. By the arguments that are being made here, what was said in Kaplan, which is that a bankruptcy trustee, once a bankruptcy is filed, is assigned all those malpractice claims. Somehow that would be against public policy, but Kaplan even realizes that once a bankruptcy is filed, all those claims are immediately transferred to the bankruptcy trustee, and there's no public policy concerns there. And the Supreme Court didn't have any issue with that either, and even said that's what happens in the bankruptcy case, and we're okay with it. On top of that, all the cases that are cited by the defendants that deal with this issue are all cases where there's a third party transfer or, I'm sorry, a sale of a claim to a third party or a creditor. All the cases that we cited are very different. They're all cases where you have a post-confirmation trust or plan done pursuant to 11 U.S.A. 1123, and they're simply just transferred to that entity to pursue those claims. It's not a third party sale, and all the cases that are cited by the defendants are all third party sale type cases. And then I'd like to briefly touch on the res judicata argument, because we haven't talked about the Northcutt versus Bryan case. That's a 775 Southern 2nd 976 to 4th DCA case. This is really the only case directly on point that deals with when you have a bankruptcy plan that's confirmed, no one objects, and then later on a party tries to go against those provisions of the plan. The court in that case found that if the order is not appealed and it's not challenged, you can't then challenge that in a subsequent suit. And that's what we have here. You can't challenge what happened in the bankruptcy case in the state court proceeding. In the bankruptcy court, it's clear that the claims were transferred to Sturmer in order to prosecute them. And you can't now challenge that here. And I've also cited some multiple federal court cases as well, including U.S. court cases that talk about once a plan is confirmed, it's res judicata, and you can't then try and attack that in a subsequent proceeding.
Well, I don't know that they're necessarily attacking the plan. I think we're talking about the plan simply because it has this, whatever you call it, carve out, this contingency. It's kind of like in my opinion, a safety net here, because if certain claims were not allowed to be assignable. So I don't think they're challenging the plan.
So I think it's in some ways they are, because this is what happened in the bankruptcy court. There was no objection. Then after that, Sturmer, not the consolidated debtor CLO, was the one who then was tasked by the bankruptcy court to hire counsel and prosecute these claims. There was no objection there. They then entered into a tolling agreement with Sturmer in his capacity to prosecute these claims. And for almost a year in the underlying state court case, this standing defense was never raised. It was first raised after the Second Amendment complaint was entered. If it was that clear to them at the time, this would have been something that was raised early on, and it wasn't. And it took over a year to really even ever assert this claim, and this was, or to assert that defense, and that was after the Second Amendment complaint was filed.
Mr. Maine, you have to wrap it up, please.
So yes, is there any more questions from the board? Thank you, Your Honor.
Thank you very much. Thank you all.
Thank you.